I welcome everyone. We're going to try to get started. I know that some folks are still getting lunch and we need to squeeze a few people in on the side. But really delighted to welcome you today. My name is Lori Achtman. I'm the Chief Operating Officer at the Penn Center for Innovation. This is the second in a monthly series about the commercialization process and how we can work with you in terms of partnering with faculty through the commercialization process. I'm really pleased today to feature some experts in patent policy. So I'll do quick introductions, and then I just wanted to ask everyone two things. If you could save your questions to the end, we are going to try to kind of wrap up the formal presentations by 20 hours at the latest, because I think there will be a great dialogue with you. And also I'm going to pass in a sign-in sheet, and if you could just write your name and your email so we make sure that we keep you in our system moving forward. Glenn, did you want to add anything before we get started? Glenn Dalton, Scientific Officer. And I'd also, before I get started, I wanted to welcome Vivian Martin, who's here. She's our new director of the PSOM office for PCI. So if you get a chance to meet her today, great. We will be setting up some opportunities to come in and do a meet and greet with her at our PSOM office in John Morgan. So without further ado, I wanted to introduce our panelists and our moderator today. First, we have Kate Donahue. She's the Director of Legal Affairs with PCI. She's been at Penn for over 8 years, so she knows the patent policy inside and out, has been working with it with faculty for a long time, so it's a great resource for all of us. We have a wonderful guest here today, Kathryn Doyle from Saul Ewing. She has been working with Penn also for a long time on RIP issues, and she can highlight herself maybe some of her recent engagements, but we wanted to bring her in to kind of give the more commercialization perspective from someone who's really guiding the patent process in partnership with us. And finally, as our moderator and also as another resource for questions, we have Jen Langenberger, who's the Director of Intellectual Property, also a colleague from PCI. She's been here for 8 years, so again, been working on these issues for a long time and is a great resource. So first, I'd like to bring up Kate Donahue to kick us off. So I'm not used to standing behind podiums. I'm used to walking around more. I'm going to see if I can move this. I can't really move it over. All right. So basically, I'm supposed to talk about the patent policy. I would like to say the ever popular and ever controversial patent policy. I first have to say that I'm a lawyer, and so I'm going to start with disclaimers. It's a very lawyerly thing to do. So first disclaimer is that I did not write the patent policy. Okay. In fact, no one at PCI wrote the patent policy. The patent policy it's an iterative policy. It has existed in various forms. The current form was adopted in 2010, but it is something that is developed by faculty committees, and that it's not to say that it's not the picture of clarity that one might like if there were a single author writing it, but anything that's written by committee is, it's the product of compromise and a lot of different things. So I didn't write it. Our patent policy, has anyone read the patent policy? Who in the room has read the patent policy? Quite a number of you. I think you will agree with me. It's how do I say this? If you have insomnia, I highly recommend reading the patent policy because it will really help with that. It's in really fine print and it's very complicated.
That being said, there are some basic things that I can say about it that are of relevance to all faculty members at the university, so that's what I like to do. Yeah, just like press it. So, the patent policy, we have one because of the Bayh-Dole Act. We receive federal funding, you know, over $850 million in federal funding each year. And prior to 1980, institutions like the university that received federal funding, if there were inventions that were conceived during the research, the federal government owned them. And typically, the federal government didn't develop the inventions unless they had a defense application. So a lot of inventions that came out of federal grants just merely sat on the shelf. In 1980, we're coming out of the 70s, there were economic issues. Birch Bayh and Bob Doyle were the authors of the Bayh-Dole Act, and they wanted to stimulate economic growth in the United States, and they thought that by allowing the recipients of federal funding to actually own the inventions, but also tie some strings to that right to own, requiring them to commercialize the inventions, that would actually help stimulate the U.S. economy. The Bayh-Dole Act was adopted in 1980. It allows Penn to own inventions that come out of federal funding, but in exchange we have to do a number of things. We have to disclose the inventions to the agency. In order for us to disclose them to the agency, we, Penn, have to know about them, so hence the requirement that inventors disclose to the university. We have to, if we seek patent, we're allowed to own them if we seek patent protection for them. We're required to try to commercialize them. We have to provide annual reports to the government on what we've done with the invention and whether there's a product that's sold, how much money we've received, etc. So we have a compliance component. There are requirements for exclusive licensees to manufacture in the U.S., preferences for small businesses, and we have to, with the revenue that comes in, we have to do two things. We have to share some of it with inventors, which we do, and we have to plow the bulk of it back into research, which we also do. So we have to have a patent policy that does these things, that allows us to comply with the requirements of the Bayh-Dole Act. That is the basis for our patent policy. The patent policy starts out by saying that the university will own inventions conceived by inventors, and these are all defined terms, in the course of employment that result from your employment duties or result from substantial use of university resources that are conceived under grants, etc., etc. And it says that the university owns these as of the moment of conception. Penn, being a Quaker institution and being somewhat conservative about things, employs what I would call the belt and suspenders approach. We have in the policy, it says that the university owns inventions as of conception, but they also have a requirement that the inventors assign to the university, and that that all researchers sign the participation agreement, which is an attachment to the patent policy. So that's like 3 different ways that the university is ensuring that it has ownership of invention. Who's an inventor? It could be faculty, it could be adjunct faculty, it could be postdocs, employees, undergraduate students under certain circumstances, or graduate students. If I come up with a novel process for commercializing inventions as part of my work, Penn owns that invention. I'm an employee of the university. So there's a link to the patent policy for any of those who haven't read it and are, after this presentation, dying to look it up. You can find it and read it yourself. So you have to assign to the university, cooperate with the university in the patent process, which Kathryn will talk about further. There's a possibility that there might be inventions that fall outside the policy, and the policy describes that as well. They can be disclosed to PCI with an explanation for why the disclosure thinks that the invention falls outside the policy. We will research whether or not it meets the criteria of a Penn invention and render a decision. We usually call it a waiver. If it's not Penn's, we issue a waiver. For example, if a faculty member arrives at the university with a portfolio of inventions in hand already, they would get a waiver. If it's, let's say it's a surgeon and they are hiking in the mountains in Machu Picchu and they come up with a camera tripod, that would not be related to their work at Penn. We would issue a waiver for that. That is an example that actually did happen. If the inventor's in the room, hello. It happened so long ago, I don't remember who it was. So, undergraduate students typically own their inventions. It's only in limited circumstances where they don't. And it's if they're employed by the university or working under a grant or there's another Penn inventor on it. Graduate students, it's usually the opposite. Typically the university owns the inventions, but we do look into situations and make a determination on a case-by-case basis. Inventions that we are not successful in commercializing may be returned to the inventor. There's a process for that. The patent policy goes into some fairly excruciating detail about the return process, the criteria, and what the inventors have to agree to with Penn upon a return. There is a revenue share requirement with the university if they are successful in commercializing, and they have to continue to cooperate with the university, disclose future inventions, et cetera, et cetera. In addition, so the revenue share is they would have to give the university 15% of gross compensation up to the first million, 10% beyond the first million. It's been rare, but we have occasionally returned inventions and actually had revenue come back to the university. Usually when we return an invention, nothing happens with it. The overwhelming majority of cases. So if there is an invention that comes out of research, what happens? You would disclose it to the Penn Center for Innovation. There's a disclosure form on our website, and there's a process. It would be evaluated at PCI, and a determination would be made whether or not, A, whether Penn owns it, B, whether there are other encumbrances on it, such as is it resulting from a sponsored research agreement or other agreement? Does it have commercial value? Only if the answer is, and can it be patented? Only if the answer is yes to those three questions, we own it. It's got commercial value. Could be patented. Do we file a patent application? So I know Kathryn's going to go into more detail on that. There are certain equity provisions that are of interest to faculty members under the patent policy. I'm being told that I'm supposed to stop at this point, so I don't know. If I'm supposed to stop at 20 after, I'm going to stop now, and we can go into further questions.
Okay. How much more is in your presentation?
A couple more slides.
Okay, why don't you wrap up?
Yeah, just
I think it will help the questions if we actually complete the presentation.
I think if we
Okay.
get to 25 and then.
Thanks. So when we license technology, sometimes we do take equity in consideration. We're permitted to do that under the policy. A lot of times we have questions about what the inventor's role can be in a licensee. An inventor can be a scientific advisor, typically, but not take an officer role or have a fiduciary duty to a licensee. Penn technology. That's because they have a duty of, they have duties to Penn and a conflicting duty to a company, a fiduciary duty to a company would be problematic for the university. So typically, an inventor can't be a board member, officer, or have other fiduciary role. Scientific advisor is totally fine. There are limitations on the quantity of equity that an inventor can have in a licensee. The inventor and family members cannot have a majority of the stock. They have to have a minority ownership, both at the time of the license execution and afterwards. And we won't negotiate a license with the inventor because they're our employee, and that puts conflict, if we're in direct conflict with them, if we're negotiating with them for a business arrangement regarding their technology. So there has to be another layer. There has to be a company set up, someone representing the company who is not the inventor. If the inventor takes direct equity from a licensee, we don't. So as I said, there's a share of income under the patent policy. If we receive revenue from licensing, we share it with the faculty member. We share the equity with the faculty member, except if the faculty member is taking equity directly from the company. We don't allow the double dipping, except in extremely, I won't say never, because at Penn, you can never say never. There could be a situation where it would happen. There's an extremely complicated revenue chart. It used to be under the earlier patent policy. It was this lovely little pie chart that was very easy to describe who got what under the patent policy. The current patent policy is not as simple, but after certain deductions, so if you deduct direct commercialization costs, the patent costs on a particular portfolio, licensing costs, then it goes 30% to the inventor, 12% to their lab. Then there are other deductions, and the remaining distribution, the remaining income is distributed 20% to the department, 40% to the school, and 40% to the research fund, which is the provost's office. So that's, I don't want to go into consulting. I think that will take too much time. That could be a whole another presentation on its own. Consulting. Okay. Okay. Yep.
Hi, everybody. Can everybody hear me? Yes. I hope the food was good, because this is really dry scrub. So, what I'm going to talk to you about, dovetailing on what Kate has already presented to you, is a little more about the patent process and the commercialization process for inventions that you all make here at Penn. And let me just go with this slide. So, the process in terms of patenting is on this slide. You disclose to your IP manager, this would be PCI. You work with a patent attorney to develop and file an application. That's examined in the patent office by a patent examiner who generally has a PhD, may or may not be as smart as you want them to be. Sometimes they're really smart, sometimes not so much. There's a back and forth argument with them, and hopefully you get a patent issued. Before we get into the details of that, though, the question is, what's that for? And the issue would be, you guys do basic research and you want to see it go out into the commercial sector so that it can be translated in some way to something that is beneficial. When you do that, the best way to get it out into the commercial sector is to get an issued patent on the technology that you've invented. When you get an issued patent on the technology that you've invented, you've passed certain tests within the patent office by way of this examination process. But if you're going to commercialize this and you're looking at a partner, the partner is going to look at your patent application as if they were either the patent office or they were the court. So the test for commercialization a lot of the times on a patent application is it any good? They're going to pretend like they're an examiner, and they're going to see if the claims of your patent application should or shouldn't have been issued. And the third test is going to be, they're going to ask if a court were to look at this, would it remain valid if the patent office allowed it? So if you think of those three things, you've got a patent office examining it, you've got a partner looking at it to see if it's any good, and potentially if it's litigated, you've got a court looking at it to see if it should still be valid. So with that in mind, now I'm going to go down through sort of the criteria for patentability, because these are the things that the examiner looks at in the patent office, the partner looks at to see if your application's any good or your patent's any good, and these are the things the court would look at to see whether or not it would remain valid. Issuance and grant of the patent was the last step there. Patent applications are a disclosure. They're like sort of a manuscript, but they're more embellished. All of the text, figures, tables that have all of your data in, but they have to disclose the manner of making and using the invention you believe you've made. The claims are these numbered paragraphs at the end of the application that are the thing that everybody fights about. They are a simple numbered paragraph, one period, at the end of the sentence, and they are the box in which your invention fits. So I want to give you some examples of claims just because it is important. This is what everybody fights about. The examiner looks at the claims to see if they're patentable. The partner, the commercial partner, looks at the claims to see if they're any good and if they're going to cover the product and if they would stand up to scrutiny within a litigation by a court, okay? So composition claims, a simple composition claim is, say, an antibody-drug conjugate comprising an antibody. It's got specificity for one type of tumor. It has a drug attached to it by a linker, and the linker can be cleaved when the tumor is, when the antibody is brought to the tumor, okay? That's a simple composition claim. That's what we call an independent claim. A dependent claim might define what that tumor is. Instead of having the broad term of just tumor, which could be all tumors, it would have a pancreatic tumor. Another dependent tumor claim might be wherein the drug is a particular composition. The examiner looks at these paragraphs and tries to decide whether or not they should be patentable. The criteria, let me just look again at a method claim instead of a composition claim. This one would be, say, treating an autoimmune disease comprising administering to a patient an analog of a compound X, thereby treating the autoimmune disease. You would have dependent claims wherein you define X better, or wherein you might define the autoimmune disease better, okay? Examiner's going to look at it and decide whether or not these are patentable based upon the following criteria. One, is it non-natural? Two, that's my cue, right? So it has to be something that isn't natural. It has to be something that is what they say has the hand of man within it. Non-natural is different from novel. Novel means that somebody else can't have made the identical thing out there ahead of you, before you did. I'm losing my little keyboard here. And then the biggest one in the field that we all work in the field of life sciences, is it has to be non-obvious. And that means that it has to be a bigger than a baby step from whatever was published before. And this is the one we fight hard with the patent office on, and it's the one we fight hardest with the commercial partner on, and in litigation, it's the easiest one usually to bring up to try to invalidate a patent. It means that there might be art out there that was published by you and by Don, and I don't know your name, excuse me, but I do know Don's name. So you both individually published an article each, which when put together would generate one of these claims, according to the examiner. And then we have to argue back that that couldn't have happened, wouldn't have happened, and that the invention that we're trying to patent and the claims we have are non-obvious over the combined two references. The other thing that's really important, and you guys need to hear this really clearly, is that it has to be an enabled invention. Whatever's in the claim, you have to teach in the body of the document how to make and use. So it can't be pie-in-the-sky speculation. You have to write down how you might make and use it. Generally, that's all the data that you generate for the disclosure that you give to PCI. And then an odd quirk to this in the patent office is there has to be a written description of what the invention is. And that's a little different. It's not that you have to teach how to make and use it, it's that you have to show the public what it is. And if you remember what patents are all about, it's a contract with the public. It's in the US Constitution where you disclose the entire invention to the public in a patent application that issues as a patent. And what you get back is a monopoly to use that without, to be able to leverage that to get licenses from others. You can prevent other people from using your invention for a period of time. And that's the contract you have with the US. So you have to tell people what it is. You have to tell people how to make and use it. It can't be obvious, and it must be novel, and it can't be a natural thing. Okay, kind of simple, right? Not hard to think about. Well, you guys are doing cutting edge research. It actually really isn't that hard. The biggest hurdles we have with technology in this area, as I said, is the obviousness issue. And the other one is if you have data on a mouse, we all love them, but we generally don't like treating them, okay? It's kind of a public policy thing. We want to be treating humans. So if you have data on a mouse, we have to write in the patent application how that's applicable to a human in a way that one of you, which would be a skilled artisan, would understand. Otherwise, the patent office is going to say that what you did in the mouse is not applicable to the human, it won't work in the human, and therefore you're not patentable. Everybody with me? Am I talking too fast? Okay, food-wise, good. So I'm not going to go, because we're going to run out of time, but if you have questions about those kinds of criteria, you can talk to me after the talk. Or Domingo Silva was kind enough to come here. He works with me, and he can take a lot of your questions too, just because he can. The one thing that will mess up your patentability is when you publish your own stuff before you disclose to PCI and before they have time to evaluate it and get a patent application on file. And if you disclosed your invention to the public prior to an application being filed, you lose almost all your foreign rights, and you may lose, after last year, a substantial amount of your US rights. And one thing that people get a lot of confused about, or quite confused about, is what a publication actually really is. So it is a scientific article, that's easy. It's a thesis. It's a student thesis that's cataloged in a library and available for anybody to search before you file. It's an abstract of a presentation that you might want to make where you have disclosed enough data in the abstract that makes the invention non-patentable. It's an abstract of a grant that is available to the public after the grant is issued, or sometimes even after it's submitted. It's a public talk or a poster that is open to people outside of your own institution. So if you're discussing your invention at a lab meeting, that's no big deal, but if you invite people from the outside and you disclose it in their presence, that could be a public disclosure. And this is one of the more important ones, where if you're trying to entice funding for, let's say you want to do a startup company around your invention, if you're doing a partnering pitch and you have enough data in there that would constitute a public disclosure, and it was presented without a confidentiality agreement. So you have this difficult issue. You're trying to attract funding, you want to write a grant, you want to obviously be able to present this to your peer colleagues. All of that ought to happen after you disclose to PCI, and if they decide a patent application should be filed, that it gets filed. One big issue that also affects whether or not your patent is any good and would be enforceable as an issued patent is this issue of inventorship and ownership. As Kate said, when you invented Penn under the patent policy, you're obligated to assign to Penn, and in fact, under the participation agreement, you do assign to Penn. Penn then is the owner, but you're still the inventor. If the inventorship on a patent application is incorrect, it can be corrected up until the patent actually expires, so long after it's issued. The inventorship can be corrected provided there was no shenanigans going on that led to the incorrect inventorship. So one thing we try to do before we file applications for you all is we try to get the inventorship correct from the beginning. And when patents issue, we might go back and revisit that and make sure we have it correct, because we don't want any shenanigans. And what kind of shenanigans would they be? Well, it might be easy to leave somebody off an application because, well, we didn't want that other institution to be an owner. Let's say we collaborated with someone else and we wanted to keep it within Penn. That might be a shenanigan. If you had some sort of commercial partner and you wanted to try to cut them out, that might be a shenanigan. Or if you wanted to put somebody on where the money would flow to them and not to some others, that might be a shenanigan. Any of those things are discoverable if this patent were ever litigated, and it may end up being the case that the patent would then be unenforceable. So that's why inventorship is really important. But who is an inventor? It's a legal determination. It's not a moral decision. So it's done by a patent attorney. It's not done by deciding who's going to be an author on your paper, because it's different. It's a much higher standard. I'm going to leave that just for a minute. So it's the person who conceived of the invention. And under the law, it's a definite, permanent idea of a complete and operative invention, including every feature of the subject matter sought to be patented. That's the legalese. The guy who's the inventor is the guy who contributed to the intellectual aspects of the invention, not the person who just did the work, not the person who carried out the experiments, even if they're at a very high level that prove that it would work once conception is complete. Reduction to practice is the guy who does the experiments. Sometimes they're one and the same people. So you can do the testing and show that it works, and you've reduced the invention to practice. If you believe your invention's going to work and you have only limited data, you can file a patent application describing how it's going to work. We call that a prophetic application. And then after the fact, using the same sort of criteria you laid out in your application, show that it does work, you can still have reduction to practice. So what I'm trying to say is you don't have to have tons and tons of data. You just have to have enough data that one of your colleagues, who's a skilled artisan under the law, would believe that it would work. Okay? Big issue is what happens with joint inventors. Most of you collaborate with each other, and you collaborate within your labs. PIs collaborate with postdocs collaborate with grad students, you collaborate across labs, and you collaborate across institutions, and sometimes you even collaborate from Penn out to a commercial entity. Joint inventors don't have to have physically worked together at the same time, okay? They don't have to have made an equal contribution to the invention. They don't have to have contributed to every single claim in the patent application, but they do have to collaborate with each other. So a coincidental invention between one institution and another, where you all didn't know what each other was doing, is not a co-invention. On the other hand, if there is a collaboration where you're both helping each other out, then it is an invention, a co-invention. Big issue here is when you're all sitting in meetings and you're brainstorming, is try to figure out who in that room is really contributing to the intellectual aspects of the invention, and who in the room is being more passive, saying, well, I know how to run that assay. Because the guy who says, I know how to run the assay, is making a real contribution to the process, but he's not an inventor. The guy who's sitting there saying, oh no, not that analog, but this one, or no, not that tumor, but this tumor, those are the guys who are contributing, or the gals who are contributing to the invention itself. I know you're going to have questions about that.
Kathryn,
And that's the other
if we could try to wrap. Oh, great.
Okay.
So I think we're going to move over to the discussion and question and answer section. So I would love to start with questions that people have from the audience, and if not, I will present a couple of questions that we frequently get in our office. So does anybody have any questions for Kathryn or Kate, or about patent policy, patent prosecution, anything along those lines? All right, tough crowd.
Why don't you kick off?
No,
Wait, we got a question. Go ahead.
You want to stand up?
Yeah, sure. Counsel Stephen, say you're working in a research field and trying to establish whether something is even worthwhile to disclose, and you look at some patents in the space, and you see these seemingly impossibly broad claims that are in issued patents. For instance, patenting this protein and any immunologically related protein that's out. Well, that could be the universe for all you know. Yet, there are clearly patents that have been the backbone of industrial development and commercialization for years that sort of build on that. An example may be some of these recombinant insulins differ by one amino acid from a natural product, and yet that patent alone is the backbone of $1 billion revenue.
Right.
You know, take Lantis or something like that. I would love if you could just engage for a minute about those issues, what issues surround
Okay.
that topic.
Yeah, you can, or you can keep it smaller.
So, that's a great question. I think that the question is, when you look at patents and you look at the claims and you see that there is such broad scope that they're covering ginormous amounts of what we think of as subject matter. And if you're gonna go commercialize your invention, would you now be infringing those claims? And you know, the lawyer's answer is it depends, but let me give you some generalities that help. Most of the very broad patents that got issued were issued quite some time back. And I think about some of the Amgen patents and others where, you know, it became a $1 billion industry. So one of the processes that happens, patent applications are filed, they issue, and then they have this long enforceable term where they're pending or they are active issued patents and can be enforced against third parties. During the time that they're enforceable in their patent term, the courts are making law that direct one as to how to deal with some of these claims. And what the courts have done in the last 10 to 15 years is that they've invalidated almost all of those very broad patents that have come up. So, and they've invalidated them because they're overly broad, because they didn't have enough written description for all of what they said, because they weren't enabled for all of what they held, and because they were obvious because they were so broad. So any patent that has not been invalidated by a court of law is still fair game to be enforced, but the chances are, if it were challenged, if it's that broad, it would be invalidated. There's a different aspect to the law as well that has become very clear. When you have, these are chemical compounds where I think of their ickle-sickle cases, forgive me to make this, he's a chemist, where you have like tons and tons and tons of different chemistry that could be within the scope of the claim. The court has said that if you cannot see the infringing compound immediately, where, you know, you've got R1 could be any one of this huge list, R2 could be any one of this huge list. If you cannot see the infringing compound almost immediately, then you may not be infringing. So if it takes you a long Sunday afternoon when there's no football to go through all of this and it's raining outside and figure out whether you might infringe, the chances are you're not. Now you can't go on that as a rule of thumb, but your partners who are doing due diligence know the same stuff I do. And they may not worry so much about some of these broad claims.
Can I just quickly follow up on that?
Absolutely, sure.
So if someone in Penn filed a disclosure about something that they feel is novel, and they actually tell the office and you, here's this patent which I think technically, here's a patent I found which I think technically is very broad and covers this, but I don't think this patent's legitimate. If Penn went ahead to file the patent office would immediately say that they won't issue the
Yeah, the patent office will make an argument.
So then would Penn theoretically go to the court and try to invalidate that patent so they can file a patent?
No, what Penn's going to do is make a leveraged sort of decision. If a patent attorney can say to Penn, look, I'm not going to worry about this as prior art or as a freedom to operate, then PCI will take that into account and maybe go ahead and file. These are arguments that we would, so then if a patent examiner says it's prior art, the arguments back are already set. In fact, you can sort of build them into the patent application. And if you overcome that art and you issue, now if somebody challenges that patent as being invalid, and the examiner already looked at that art, there's this presumption that the examiner did his job and that the patent is valid. So if there is that art around, you should always give it to PCI. Don't, for goodness sake, not give it to them, and let a patent attorney take a look, and then give PCI a weighted sort of risk assessment on whether or not it's worth going ahead or not.
I think it's also important to try to distinguish patentability from freedom to operate. So the patent office is only looking at patentability. Is this novel? Is it new? Is it not obvious? Is it enabled, etc.? Whereas if a broad patent, like you were talking about, issues that covers everything, the patent office might allow a more narrow and more specific to a specific immunological molecule, etc., that might actually fall within the scope of those broad claims. So us, as you have the inventor and Penn is the owner of the patent, we would look at both issues. Do we think this could be considered non-obvious over this? The patent office is almost looking at it as a publication. But also, do we think this patent is going to present a barrier to commercialization? Because technically, when we practice this invention, it's going to infringe this broader patent. And that's when we look at, is this patent? Patents are presumed valid and enforceable, but some of them, you're absolutely right, when you look at them on their face under today's current law, we would hire an attorney to render us an opinion that said, no, I don't think this patent would be valid or enforceable. And that's also something that we would look at with our potential commercial partner. What product are you making? Does our patent cover it to protect you so you could prevent others from practicing it? But also, if there's anything else that covers that product, are we going to be able to, are we going to need to take a license from those patent holders? Or do we think their patent is not valid and enforceable and therefore we're just not going to worry about it? So that all ties in together. So.
And when people who own those very broad patents now, think about enforcing them, they get very, very nervous, because the minute that they, like, if I enforce a very broad patent against Don, because he's, I say he's infringing my patent, the first thing Don's going to do is file a counterclaim that I'm invalid. And he's probably going to win under the prevailing law.
Yeah, the patent law is
so people aren't enforcing those broad patents either, because they know that they're going to fall.
Right. They don't want to jeopardize. If they've got a broad patent, they're less likely to enforce it because they could jeopardize that patent itself. They'd rather just kind of keep it as for its chilling effect.
Yeah, exactly.
On others. Yeah.
Are there any other questions? Okay. The other thing that okay, go ahead.
Just one other.
Yep.
In the realm of medical methods, would you comment on the 287C exemptions?
287C exempt, can you elaborate?
My understanding of this is that 287A under CFR describes what it is to be infringed. B describes what your recourse is if you're infringed, how you can sue them.
271, you mean, I think. The safe harbor?
No, but then C supposedly was the brainchild of Senator Frist, the former cardiac surgeon for Mass General turned senator, who was nervous about surgeons patenting operation.
Yeah,
Who
okay.
then said, you can patent these things all you want. The problem is you just can't force them. Which will all be under this exemption, whereby the patent that you think you have is completely useless.
Well,
So that's what I would love to see.
yeah, so I think some of that goes to, you can patent devices, you can patent instruments, they're things. You can patent uses of them in a body. So the use of a device to detect something, the use of a device to probe something within the body. They're all patentable. What's not patentable under what you're talking about is a procedure that doesn't include a man-made device. So a way of doing something in the body to redirect something using nothing other than the surgeon's hands and some sutures. That's a non-patentable process. They've decided that there should never be any monopoly on that. And that's the policy you're talking about.
I think also, I know that we've had a disclosure that came to us of a surgical procedure method, and I think as an institution we decided that that was not something that we wanted patent because we would not prevent other people from using it. We just didn't even get to that level of, it was more, as a nonprofit institution, there are some decisions that we're going to make on a public policy basis, and it sounds like they may have been codified as well.
Yeah, as far, as a health system, as a university associated with the health system, there are certain decisions that we make. There's also decisions that we make on patentable subject matter where it's just almost never commercially feasible to file on something. For example, in the United States, you could file on protection for a knockout mouse, but we don't tend to do that as policy because it's just the cost-benefit analysis doesn't make sense. So a lot of times, even if it's not explicitly stated in the CFR, there's just certain practices that we've adopted because we would not be willing to, there's a patent is worthless if you're not willing to enforce it, and we would not be willing to enforce that sort of patent in principle, like, you know, from a 50,000-foot view.
Thank you.
One of the things I'm going to add on a little bit to that came up recently was we had a question from a researcher about the fact that if we license some of their technology, some of their background technology that was fairly foundational to the work they were doing, whether they could still do research in that area, come up with new inventions, maybe license those inventions to a startup company, that kind of thing. And the fact is that in our licensing, in our commercialization process, we always reserve for the institution, for Penn, the ability to use the inventions that were developed here for academic and research purposes. Sometimes we get them for clinical care purposes as well, sometimes we don't, but always for academic and research purposes. So whatever has been disclosed to us, if we license that out, even exclusively to a big company, you can continue to do research in that area, in your field, develop new inventions, etc. And whoever would license the new inventions, the improvements maybe, they will have to deal with the freedom to operate issue. So they might have to get a license from the old co for the background technology, or the converse. The old co might have to get a license from new co to exercise the improvement. So it's a little bit of a Venn diagram. You can have an invention that's broad. Let's say it's a compound, and I'm a non-scientist and I'm not a patent lawyer, so excuse me if I say, correct me if I say it wrong.
Compound is good. It's a good
Okay,
description.
so you come up with a compound, that might have broad applications. You continue to do research and you find a method of use or an indication that is really good for, and have a second patent on that. You've licensed, let's say Penn has licensed the compound to somebody, they can use it for whatever they want, except if we've got a patent on the new, they can't use it in the new area unless they also get a license to that from us. So,
Yep.
Thanks, Kate. So I thought I could just do a little wrap up. So first of all, I wanted to thank our great panel here for joining us. I hope you get the sense that we have a lot of expertise at our disposal at PCI, both in our office and then also via our legal partners. I wanted to highlight the fact that we will put these presentations on our website, and we have video today, so we're going to try to put some element of what happened today up on our website as a resource for you. I also just wanted to highlight if Vivian, Shilpa, Lena, and Camilla could raise their hands. Again, Vivian's the director of our PSUM office, which is on the second floor of JP Morgan. We need to get a sign there, but it's right across from Glenn's suite of offices. These are your kind of boots on the ground to work directly with you, the faculty, on this commercialization journey with PCI. So that should be kind of your first stop, and they work with kind of the central office as needed on all of these legal and patenting issues. So again, we're trying to be closer